Well, welcome to Security in Depth's Mandatory Data Breach Notification webinar, What You Need to Know. First of all, I would like to introduce you to today's presenters. First and foremost, I'm proud to present from DLAPiper, Tim Lyons. Tim is a partner at DLAPiper, one of the world's largest law firms. He heads up the intellectual property and technology team here in Australia. Tim advises on information, technology implementations and outsourcing transactions. Most transactions he sees involve a cloud component and large amounts of data held by external organizations. In these circumstances, there is always a risk of data breach, from the very minor, involving unauthorized access to data, to major releases of sensitive information. Tim advises several government departments and major agencies in respect of their obligations under state and federal privacy legislation, and he has previously been awarded the Government Lawyer of the Year in Melbourne by the Best Lawyers publication. Also on the call today is Hayley Weller. Hayley is a qualified lawyer and practices as a commercial lawyer in regional Victoria. She now volunteers with the Animal Law Institute, advising not-for-profit organisations and advocates on commercial-related legal matters. Hayley is currently working across probity and is supporting Security in Depth with this presentation. Today, what will occur is that all your questions via text will be answered by Hayley. And then there's myself. I'm Michael Connory. I am the CEO of Security in Depth. To give you a little bit of background about me, I have an MBA in International Business from Deakin and a Bachelor of Economics. I don't know how I got into security. I think it was that I hacked my first computer when I was 12 years old and always loved security ever since. I'm the CEO of Security in Depth. I'm the chairman of the whole of Victorian Government Privileged Access Management Working Group, non-executive director at the Camino Group of Companies, and held non-executive director positions at Triathlon Victoria and the Camino Investment Group. I've been involved personally with implementing security and identity solutions such as Telstra, the National Australia Bank, ANZ, both state and federal government departments, and the Australian Department of Defence. For good or bad, I've also held roles at Oracle and Microsoft. So what I'd like to do, just a little bit of housekeeping to begin with. For any questions you may have during this presentation, please text these through to Hayley. The text number is 0412 516 059. Please include your name in any text. We won't read the name out, but it'll enable us just to identify who you are, so we can put it together. Now, if you are really interested in a detailed legal version of this presentation, please email research@securityindepth.com.au. We do have a very, very specific legal version from this. So you understand there's two lawyers in the room here, and they're very aware of what the legal requirements are. And throughout this, in the future, when you're going through the data breach legislation, if you have any legal inquiries at all, I can't stress how great Tim is, and I would highly recommend utilising DLAPiper and Tim. And there's Tim's email address, tim.lyons@dlapiper.com. So, without further ado, let's get into the presentation. So, the reason we're here today is to discuss the new data breach laws for business. What we'll do is we'll work through a number of real scenarios that Security in Depth have helped organisations with within the confines of a fictional organisation. What we really want to focus on is how the legislation is designed to be a perfect balance between protecting individuals and not being burdensome on organisations. That being said, the better policies you have, the better structure you have, the better prepared you will be for managing a data breach, and it will be easier for you to comply with the new legislation. So what I'm going to do is I'm going to hand it over to Tim to talk about the Privacy Act.
So Thanks, Michael. Look, the underlying legislation here is the Australian Privacy Act, which of course has the Australian privacy principles underpinning that act. The legislation in question that brings in mandatory breach notification tomorrow is the Privacy Amendment Notifiable Data Breaches Act 2017. It comes into force tomorrow, but it's important before we dive into the legal ramifications of that amending legislation to understand the objectives underpinning the Australian Privacy Act and also all privacy legislation. And the objectives, as expressly stated for the Privacy Act, include promoting the protection of privacy of individuals, recognising that the protection of the privacy of individuals must be balanced with the interests of entities in carrying out their functions. And the most important one, I think, for the purposes of today's discussion, promoting responsible and transparent handling of personal information by entities. So this amending legislation supports that objective, in particular, the aspect of transparency in terms of handling of information, because if there is a data breach, it wouldn't be transparent to hide that breach. So this legislation talks about when is notification required and how to actually give that notification. Now, you'll note that we've only referred to the federal legislation here. There may be some people attending the call who work for state government organisations. This legislation doesn't amend that state legislation. However, because of the principle of transparent handling of personal information, which underpins all privacy legislation in Australia, the principles we will discuss would be equally applicable to other organisations who are not APP entities under the federal privacy legislation, and that would include state government departments and agencies.
So, why is this legislation important? Well, the Australian government wants to ensure that individuals, and that's each and every one of us, can, if our personal information is compromised, take steps to protect ourselves. That's the government creating a law that allows the law to catch up with technology. As you would be aware, there are a significant number of data breaches over the last year. We've been able to see and track more than 4,000 within the region. With the scheme in place, we will expect that to increase exponentially. Now, the other component of this is that it's also designed to help organisations improve their security practices. You know, the focus here is not to be a deterrent against organisations, but it's to help organisations become better at managing their security, managing the data that they're looking after. You know, and the focus here is it aims to strike a balance between, you know, promoting the rights of the individual and making sure that an organisation can look after its data, which is a very significant asset of the organisation. So from that, really what we're looking at is, are you prepared? Is your organisation prepared for the data breach notification law, which comes into effect tomorrow? When we had a look at some of the statistics, our own research department at Security and Depth, when we reviewed, I think we reviewed 900 organisations, only 27% of organisations currently have an incident response plan that is ready for the data breach notification law. You know, when we have a look at it, phishing attacks are on the increase, data breaches are going to be increasing, ransomware is on the increase, organisations are being targeted and attacked consistently. But it's not just from an outside influence, it's also from an inside influence. And the component here is that how is your organisation going to be impacted, and what's that going to mean to the bottom line? From the statistics there, 31% of consumers impacted by a breach stated that they discontinued. If you had a look at some of the organisations that were breached last year, Equifax, and prior to that, Target, their share price and the value of their business dropped significantly over a period of time. So the question is, data breach is more likely to happen within your organisation than not. It's not simply about, putting together a plan and hoping that you can communicate and get out of it. Once a data breach occurs, you now have legal responsibilities. So, what we're going to focus here is a fictional company. We're going to take you through a number of processes and a number of solutions for MJC Finance, so Michael James Connory Finance. This fictional company was formed in 2002. Essentially, it's an accounting firm. It currently employs 537 full-time staff, revenue of 827 million. So it's quite a large organisation, or it's a medium-sized organisation. The head office is within Melbourne and operates only within Australia. So the next component of this is, as MJC Finance, do I fall under the guidelines for this new legislation? And what does that mean?
So just briefly, Michael, yes, you will fall under the new legislation. So the Privacy Act, as I mentioned before, applies to APP entities who can be an agency, which is a federal government agency, being departments, courts, other agencies, etc., or an organisation or a small business operator. An organisation that needs to comply with the Privacy Act is one that has annual turnover of more than $3 million, which is why your company is called, or provides a health service to a person, or is an organisation that trades in personal information, or is a contracted service provider under a Commonwealth contract. Organisations can be individuals, body corporates, partnerships, unincorporated associations, trusts, etc., that is not a small business operator or a registered political party or state or territory authority. So as I mentioned before, this legislation doesn't apply to state governments, but basically it applies to anyone else if you meet those other prerequisites, around turnover of 3 million being the key one.
Okay, great. So, under privacy laws, it seems that MJC Finance has an ongoing obligation to protect data and to be able to provide a safe solution so the data impacting individuals isn't compromised. So what we're talking about here is from an organisational perspective that I need to look at, the questions that I'm asking myself is, where is my data held? Thinking about this, where is my data held? It's easy for me to believe from a CEO perspective that it's just held on service or in the cloud. But when I sit down with my CIO, it's easy to forget that data can be on your laptop, it can be on your iPad, it can be on your mobile phone, it can be on a USB device. And what this law is asking me to do is make sure that as an organisation, I'm taking reasonable steps to protect my data. And that's really through two different areas. The first one is through governance, making sure that MJC has the right policies, the right procedures, that we've got an incident response plan in place, that we know what we're doing if something actually happens. The other component from taking a reasonable step to protect my data is, and it could be simple things like we encrypt our hard drives, we have two-factor authentication to be able to access certain applications, especially when we're on the road. We have the latest firewalls and antivirus software. So what we're doing is we are taking reasonable steps to ensure that the information that MJC holds is secure. So then we go on and we talk about how a data breach could actually eventuate. Now, we've put up a couple of scenarios here, a number of scenarios. Phishing, files accessed by the wrong person, lost laptop, lost USB, lost smartphone, being hacked, or even misplaced files. I was in an organisation a week ago, and they still had a significant number of files sitting on desks that were not being attended to, that held private, confidential information on staff members. The other area, phishing is a consistent threat these days. An employee just clicking on the wrong email, on the wrong link, could inadvertently provide information that the organisation is not prepared to give. One of the really interesting things here is that files accessed by a wrong person. We've got an HR system in place, and our HR system manages all of the performance reviews and holds all of the performance reviews of all of our staff. Now, within that, from my understanding, if somebody inadvertently accessed that HR system and started to look at those HR files and the performance reviews, that's a data breach. If I leave my phone on the tram and my phone has got Salesforce on it our Salesforce database is quite substantial. If somebody accesses that and gets to it, that's potentially a data breach. So, a lost USB, we have lots of discussions with organisations around lost USBs, and most organisations lose them. If there's personal information on that USB stick, that's a data breach, because what it means is that there's been unauthorised access of information, there's been disclosure of information that shouldn't have been disclosed, or there's loss of information. And these all lead to what actually is considered a data breach.
So under the legislation, what is a data breach that needs to be notified? Well, data breach is defined as where there is unauthorised access to, unauthorised disclosure of, or loss of information where unauthorised access or disclosure is likely. So just to run through a couple of examples, and it's important to understand that there are different circumstances that each of which constitutes an eligible data breach. Unauthorised access, I think Michael's given a couple of examples there. Another one, and we always think of databases and phones, etc., but an important data breach that occurred that I'm aware of and have provided advice on was a simple matter of someone trying to be environmentally friendly, picked up some paper out of a waste paper bin, turned it over and used the blank side of that paper to write notes and give some information to someone who came to a customer service desk. Now, what they'd pulled out of the bin was actually some sensitive health information, and that was on the back of the sheet. So in fact, this person, with their wad of paper at the front desk, being very helpful and providing excellent customer service, was actually involved in a significant data breach by handing out these pieces of paper that related to individuals with health information on them. Unauthorised disclosure, that can occur in a couple of ways, but that could be deliberate malicious acts by an employee, or as we know, there's been a couple of publicly notified serious disclosures where data was just made available through websites, and that's occurred on a number of different occasions, but it's still an unauthorised disclosure. And then, of course, loss of information. And the example there Michael referred to, where things are left at airports, on trams, etc. And there's been, again, a number of publicised incidents where that occurred. Now, not all data breaches are eligible data breaches under the legislation. So for an eligible data breach to exist, there are three general criteria. There must be that unauthorised access, disclosure or loss of the data. The breach must result in serious harm, or is likely to result in serious harm to an individual. We'll get to that later in this discussion. And the breach couldn't be prevented, or the serious harm couldn't be prevented through remedial action. And again, we'll get back to that point later, but at the moment it's just important to note that eligible data breaches can involve unauthorised access, disclosure or loss of that information. So when I mention information, what is the information that we're talking about here. And there's actually a couple of types of information. There's personal information, credit card data and credit history, and also tax file numbers. But personal information in particular is any information or an opinion about an identified individual or an individual who's reasonably identifiable. I don't propose to talk a lot about this. I'm assuming most people on the call understand what personal information is under the Privacy Act, but if you need to have any further information on that, we'd be happy to assist.
So what happens now? MJC suspects, and all you need to do is suspect that you have a data breach. Somebody comes to you, somebody comes to your manager and says, you know what, I've lost my iPhone, or I've lost my laptop, or I think somebody's been accessing our HR files. The moment you suspect a data breach has occurred, the clock starts ticking. And what that is, it's a 30-day clock where you need to assess the data breach. And for this, we strongly recommend that you have a fully prepared incident response plan. Now, when we talk about the clock starts ticking, what occurs is the first step that you need to look at is you need to contain the data breach. And that means that you really need to step out and decide, what to do. And that is, you need to limit further access. So if somebody's hacking into your system, you need to be able to stop that. If somebody's, if you've lost your iPhone, well, potentially, depending upon your own policies, what could occur is you might delete the iPhone, you might wipe the iPhone clean. You might have a laptop where you can remotely wipe it as well. So you need to limit further access from other people. You need to also limit the distribution of the affected personal information, and that's part of taking stock of the type of data breach that you're experiencing, and limit possible compromise of other information. So what we're really focusing on then is, a proper full incident response. So there's a three-step approach here: initiate, investigate, and evaluate. So, is an assessment necessary, and who is internally responsible? Now, when we're really focusing on this, again, somebody comes to your CEO or your ICT manager and they say, we think that there's been a breach. So what occurs is that the organisation needs to have a team ready to roll and to assess the breach. Who's responsible internally? Do you have a plan? Do you have people set up and ready and understanding what they need to do and how they need to look at this? What then occurs is you need to investigate, gather information on the suspected breach. When did it occur? What time did it occur? Is it internal? Is it external? Is it loss? What can you actually do about it? And finally, evaluate. Make a decision based on the investigation about whether the breach is an eligible data breach. So is it impacting a person? Because one of the things that's really interesting about this legislation is if the information is simply about an organisation. So, for example, as MJC Finance, we hold financial information on companies. Now, if we lost information on a company or an organisation, an individual hacked in and asked and took the information on a company, just the financial information, that's not impacting any individual directly, and therefore is not an eligible data breach. Now, one of the key things about this is that you need to document everything at each and every step, because if you're not documenting everything, if something eventuates and you have to notify, the chances of repercussions from the LAIC, the Office of the Australian Information Commissioner, can grow. So when we're talking about a mandatory data breach, what we've done here is at MJC Finance, we've done a decision flowchart. Now, first of all, we did get our lawyers, DLAPiper, to help us out with this specifically, because if we hadn't, we would have been in trouble. But the first step we do is do we suspect that a data breach may have occurred? Okay, we do. So in this instance, what we're focusing on is an email blast. What has occurred is one of our staff members in our marketing team sent out a newsletter to 4,300 customers. And of those 4,300 customers, they forgot to blind copy everybody. So everybody can see everybody's email address. Okay. So do we suspect a data breach has occurred? Well, yes. Has a data breach occurred that involves personal information? Well, this is an interesting thing. Does an email address actually mean it's personal information? And again, the reason why we ask this is that half the CEOs that we've spoken to and surveyed on this said no, half of them said yes. And when I spoke to our lawyers said, be conservative, yes. But that's up to you. So then you need to undertake a reasonable and expeditious assessment. Is a breach identified that involves it? Yes. Is there a risk of serious harm? Now, we haven't got into serious harm yet, but we will. In this instance, what can occur? Somebody might be able to access those 4,000 odd email addresses. They recognise that they're from MJC Finance, and they might start to phish them. There is a potential for risk there. They might start to see if they can utilise the information for personal gain, because they might try to sell that information off to a competitor. These are competitive emails. So that there are possibilities of serious harm there. So if it's no serious harm, we don't have to do anything about it. We don't have to report. Can remedial actions prevent the risk of harm? Now, this is the really interesting component, remedial actions. In this instance, if we send out, and this is on the advice of our lawyers, if we sent out an immediate apology and stating, we apologise for sending this email out, we didn't intend to do this, we are not going to ask you for any future information or any actions from this, and if there are any concerns, please contact us. That can be enough to be able to say that you've remediated this particular breach. And therefore, you can say, yep, we've remediated it, yep, there's no mandatory obligations to notify, and we can leave it at that. However, does an exemption apply? Well, we'll get into exemptions in a little bit as well. If they don't, what occurs is that you will need to report this breach to the LAIC, and you will also need to report this breach to the individuals involved. So the next component is serious harm.
So under the legislation, the test is, would a reasonable person consider that the data breach would be likely to result in serious harm to an individual? The explanatory memorandum to the legislation says serious harm can include serious physical, psychological, emotional, economic or financial or reputational harm. So there are a number of different categories of harm that you would need to consider when considering whether serious harm has occurred. In terms of what to consider, you need to look at the type of information disclosed. So in the case of the email addresses, that's probably a low level of risk information in that, for example, my email address may be on the membership list that Michael talked about in his example, but my email address is also freely available on the DLAPiper website. So you might say, well, this type of information, it may not be sort of high risk information. Credit card personal information as well as credit card numbers, obviously much higher risk there because we are talking about potential for financial harm. Name and address information and the types of things that are on this slide could lead to identity theft. So if you license and passport details, etc. So you need to look at the type of information. You then need to consider the circumstances of the breach. Whose personal information was involved? How many individuals were impacted? how long has it been accessible, and was the information encrypted, anonymised, or otherwise inaccessible. So in this example, or something Michael mentioned earlier, if you left a phone on a tram, but it's encrypted and also password protected, it is actually technically a data breach because there could be some unauthorised access to that information. But the likelihood of the serious harm occurring there, a reasonable person would say, look, it's very unlikely that this will result in serious harm because it's unlikely that the data could be accessed. And secondly, if you have the facility to enable the iPhone to be wiped and the person realises 1 minute after they've left it on the tram and they otherwise somehow contact their workplace and their workplace wipes the phone, well, the likelihood of serious harm occurring is low. And the third circumstance is the nature of the harm. And again, if my email address is released, the likelihood of harm to me is probably low in that I've received training on not to respond to phishing emails. But if the data that's been released is the full details of someone, for example, who is the subject of a protective order or something like that, where their name and address in particular need to be kept confidential, or the nature of the harm there could be very serious physical harm if that information was released. So you need to look at all of those factors in considering whether or not serious harm is likely. Looking at remedial action, I've just discussed the phone example, but any steps you can take to reduce potential harm might include recovering that lost information before it's disclosed, changing access control, and of course notifying individuals, which is the purpose behind this legislation. Michael also mentioned that there are some exceptions to notification, and the exceptions to notification occur where you have taken sufficient remedial action in response to the eligible data breach before it can cause any harm. This exemption refers effectively to early detection and action, and sufficiency of action is determined where you've got a high degree of confidence that the harm will not occur.
So one of the things about going through this process is that the decisions are made by, in this instance, MJC Finance. And when we talk about data breach legislation and if this is impacting your organisation, the decisions around, assessing, evaluating, remediating, what we're talking about here is that your organisation needs to have a team that will make these decisions. Because it's up to you to determine whether or not a serious data breach has occurred, whether it's eligible, whether it causes serious harm, and whether or not you need to notify. And that's up to you. There's specific guidelines that are available, and we can help you with those guidelines. Kim can provide assistance as well, but it's really important to understand that it's the organisation's executive team essentially that's making this decision. Now, when we get back to this, it's the organisation, in this instance MJC, that is reviewing the incident. So what we're going to do is we would recommend reviewing the incident in detail, and depending upon the seriousness of the incident, if it was a lost iPhone, yep, not a problem. We would say, okay, it was wiped. That's not an issue. If it was somebody's iPhone and they chose not to wipe the data because they felt that they had pictures of their 2-year-old cat who they love dearly and refused to do it, you need to have appropriate policies and procedures in place to be able to work through those types of issues. Most organisations these days don't provide smartphones to individuals. They're BYO devices. And the question is, do you have the right governance process in place to manage that? But when we're talking about a more serious one, we're talking about, let's have a look at the cause of the breach. What actually happened and why did it happen? Now, I did hear a story a while back of an organisation that did get hacked. And they discovered that they got hacked, and they discovered that a number of their confidential data files were taken by a third party, and this third party was essentially ransoming the information. The first thing that they did was that they actually got in a cyber forensics team. And the reason they got in a cyber forensics team is that they wanted to be able to analyze and understand what caused the breach. And not only what caused the breach, what information was specifically taken, when it was taken, how it was taken. And by understanding that, what they then did was that they were able to create a prevention plan around managing those types of incidences in the future so it wouldn't happen again. They conducted an audit and reviewed the entire process. One of the things that they also did in updating their response plan, they decided that they were going to take the information of the cyber forensics team and present that to those individuals that were impacted to demonstrate, what had happened, why it had happened, how it had happened, and the remediation that took place. It's also critical to be able to communicate with staff internally what eventuated and what not to do. More often than not, breaches occur because of an individual within the organisation. You do get third parties that will hack into your system, but most data breaches will occur because of an accident that an individual did. Configuring a web server incorrectly, sending out an email incorrectly, losing information, having a weak password. There's a whole range of different things. But, it's important to be able to take the incident, look at your training and help develop your staff to ensure that these things don't occur again. Finally, and this is a really interesting component, you have the choice of reporting the incident to relevant bodies, and that could be the police. If credit card details were taken, you might want to report it to the police as part of the requirements. What's not listed here is that you might actually have to report the incident to your insurance company. We haven't spoken about cyber insurance, but if you have a data breach, that data breach may impact your cyber insurance. So something to think about and look at. Reporting incidents to banks, to ASIC, to APRA, depending upon your organisation. And if your organisation operates in multiple jurisdictions, other regulations may apply, especially in Europe. I think, Tim, it's May the 25th?
Yeah, when the GDPR
comes in. So if you're dealing with European citizens and information from Europe, and you have a situation over there, you might be under their jurisdiction as well. So it's important to understand all of the requirements.
So the last step in the decision tree that we looked at before was relevant exemptions, and one of those might be that multiple entities have been affected. So this would be the case where there's, for example, a cloud service provider who has a customer's information released, and either the customer themselves or the cloud service provider, only one of those two entities needs to notify individuals. There could be an inconsistency with the secrecy provision, so actually telling anyone that there has been a breach might in fact be prohibited. And also where the OAIC says, look, you don't need to comply or notify here for various reasons, and that might be on balance because the notification is no longer necessary because it's either too late or because it's seen that there's not a likelihood of serious harm. So let's assume that you've come to a decision and you do need to notify. What do you need to notify? So first of all, you need to draft up a notice that sets out the identity and contact details of the entity concerned. So in this case, it's MJC Finance. A description of the breach that the entity believes has happened. So for example, we published all these details on our website, or in the email example, we sent out an email blast. The kinds of information concerned, so you need to say, it was your email address that was disclosed, versus we left an entire file on the tram, which would be more concerning. And then, and this is probably the key part of notification requirements, recommendations about the steps the individual should take in response to that eligible data breach. So in the case that, the example that Michael came up with before in the email blast, you might say, we've released your email details to people. Please do not respond to further emails allegedly from our organisation asking for credit card details or other information, because we will not send that sort of request to you in future. If it's credit card information, you would tell people, or you recommend that they might want to cancel that card or put a block on it and have a new card issued. What you need to look at is the kind of information that's released, the sensitivity of it, and what might be the nature of the harm in formulating what your recommendations in that notice should be. Who do you need to give the notice to? Well, you've got to give it to the IIC, and you've also got to give it to the individuals. Now, people are always concerned, does that mean I need to email each individual person, which in the case of a large data breach could be a large number of people? Do I need to find out their email addresses? Do I need to send them written notification in the mail? How do I actually notify them? Well, there is some good news here. The guidance suggests that the way you would notify the individual is the same way that you would normally correspond with that individual. And in the example before that Michael raised, which is the email blast out to individuals, if you normally do correspond with them by that means, well, you should correspond with them in that way as well. And often it's the case that the notification would simply be a publication on a website. It would be rare where you actually need to go out and pay for advertising, for example. And in fact, in the case of most significant data breaches, the newspapers will do that for you for free by advertising your data breach, but you probably want to get ahead of that notification by the news by contacting the individuals.
So Tim, I've got a question for you. If within MJC we send out information and an at-risk individual was compromised, how do we remediate something like that when a person who's at risk of danger, how would you manage that?
So if you are aware that the information you actually released could result in that serious harm, I think in that particular circumstance, if you're already aware of that, you want to contact that individual individually as quickly as possible and let them know, so that you have then complied with your obligations of notification under the legislation. And again, going back to one of the very first things I said, all of this privacy legislation, it's about transparency. So if you've actually contacted the individual and you let them know this is what's been released, this is what we recommend you should do, that's where your obligations under the Act have been fulfilled.
Okay. And if we don't?
If you don't, there are some penalties for failure to notify under the legislation. So a person might actually complain to the Privacy Commissioner, and the Commissioner can then investigate. That will actually involve costs to your organisation. So if people don't want to notify because they're concerned about the cost, it's probably going to cost more if you need to respond to an investigation. At the end of the day, the Commissioner can then also make a determination requiring compensation to individuals. They can ask for enforceable undertakings, and that would be the case where most likely there's been a deliberate disclosure rather than an accidental one. So circumstances where a marketing organisation sells a whole lot of information that they shouldn't have had in the first place, there would be an enforceable undertaking given by that organisation that they wouldn't do it again. It could, however, take the form of a request that an organisation in future takes reasonable steps to protect data. So if data is just not protected and there's no security around that data, well, it is theoretically possible that the Commissioner could say, you need to give us an undertaking that you will implement reasonable security measures in future. Again, the next thing the Commissioner can do is probably only likely in the case where there's been deliberate data breaches, and that's seeking an injunction regarding conduct to prevent that further action. It's not likely that the Commission is going to seek an injunction where there's been an accidental loss of data or unauthorised access. And then there's civil penalties of up to $2.1 million for the organisation and $420,000 for individuals. And again, the maximum fine would likely only be imposed by a court where there has been some deliberate action as opposed to accidental actions.
Okay. Does this mean that if there is a data breach and an organisation released private information that did actually cause harm and serious harm, that this is all that they need to worry about?
Well, that is the question that is forming in the minds of all lawyers. What might happen is there could be a separate class action, which has nothing to do with this legislation, where there has been some basis for that action, for example, negligence. If an organisation has taken reasonable steps to protect data, but a third-party actor has managed to circumvent that security and get hold of the data, it's less likely that the organisation would be guilty of negligence or some other tort or action giving rise to liability outside of this legislation. But in the case of deliberate breaches or failure to take due care effectively, failure to take those reasonable steps to protect the data, there could well be the prospect of a class action.
So MJC is not in trouble then. From my perspective, it just means that we've got new responsibilities. From an organisational perspective, from a governance perspective, we need to ensure that our policies, our practices, our procedures, and our systems are in place. Now, the legislation comes into effect tomorrow. What happens if they're not in place as of tomorrow? What does that mean? Do we need to do it? What would you recommend?
Well, under existing privacy legislation, you should have already had in place reasonable steps to protect personal information. If you haven't, then even more so, you want to get those steps in place now. And I think you've mentioned a couple of times you should have an incident response plan in place now so that if or when this occurs to you, you've got some actions that you can take immediately and it's all set out. You're not going to be sitting around the conference table saying, who do we contact? What do we do?
Okay, great. Now, we've just got a question through, so it's a really interesting component, a question. So does it really mean, when we talk about a data breach and we talk about controlling it, does it really mean that we need to stop access right now? Incident response sometimes means you need to investigate it.
There's two aspects to that. One is the technological one and one is the legal response. The legal response would be if there is a likelihood of ongoing access, then yes, you would need to prevent access to that data. The technological response is exactly as you state. You would need to investigate to see, well, is this a one-off or is this something where there's a back door that's currently open in our systems which we need to close down?
Yeah. Okay. So the other component of this, and as a CEO, I'm worried about having to notify that our systems have been compromised. It really concerns me. We see large organisations, their brand diminishes very quickly. Equifax, Target, some don't. We saw Deloitte. Deloitte had a significant breach and they seemed to manage it very well. The Australian Blood Service had a significant breach and managed the process incredibly well. I'm worried about it. What do I do?
So under the legislation, the legal answer is you don't have any choice anymore if it's an eligible data breach. But from the aspect we were talking about before, which is that class action, if you've actually sent out a notification that recommends the right course of action by individuals and the individuals take that action, that will actually limit the liability that might attach to you later. Whereas if you keep the data breach secret and losses are incurred as a result of the individual not knowing that there has been a breach, then that could actually give rise to a later and larger damages claim. So in fact, my recommendation would be if you follow the legislation and notify individuals in the proper manner and enable those individuals to minimise or avoid that risk of serious harm, you're in a better position legally. Reputationally, I think your incident response plan should probably have immediate notification to your PR consultant, and they'll help you potentially cast that message in a way that's likely to be more favourable to your organisation than otherwise might be reported in the media.
Okay. We've got a really interesting question that's just come through, and the question is, we've got staff of 600 odd people. There is no, how do we get them to tell us that they've done something? What happens if they don't?
Well, the organisation itself is, of course, responsible for notification, regardless of whether the staff member has actually told them. I think you would need to have, again, a mixture of policies in place and education of staff to make sure that they're in a position that they understand they're not going to be personally, sacked or other action taken against them, but encouraged to actually notify the organisation what has occurred. But again, you would also want to have, I think, some technological measures in place so that you can know when something's happened, even if it's by accident. And that's all part of taking those reasonable steps to protect personal information from unauthorised access, loss or disclosure.
Right. So coming to the end of the presentation, we'd like us to talk about Breach 101, the importance of having a plan. First of all, create a breach response team. If something occurs, have the team ready. Know who you need, know who you need to go to. Who do you need to communicate? Who's going to be best at managing this? It might not be just the ICT team. You might need to have your CFO from the risk perspective. You might want the CEO in there. You might need the HR department, depending upon whomever it is. So make sure that you actually have a multifunctional team within this ready to go. To determine the vulnerabilities, you need to have a look at, where your data is and how important it is, and what the impact could be if that data is lost or if that goes out. I know personally that if we send out data, we would not like to have a conversation with our clients saying that it's in somebody else's hands. Establish forensic and tech capabilities. You need to know what's happened, where it's happened, why it's happened, and how it's happened. And by understanding that, you'll be in a much better position to stop it happening in the future and to being able to address the remediation issues. If you're a larger organisation and you've got cyber insurance, you need to contact your insurance company, because they may direct you to a specific course of action. That's something that is yet to be reviewed, but it's very possible. Identifying legal and regulatory obligations. For us, not just at MJC, it's Security in Depth. DLAPiper, we highly recommend Tim. We would suggest that, if you've got a legal question around data breach and if you need help from a legal perspective, get him involved. Create a playbook. You need to know what you're going to do, how you're going to do it, and you need to test it to make sure it works. It's critical in all responses. Evaluate comprehensive identity theft services. And this is really, providing a potential solution to some of your customers, some of the individuals who may suffer a breach and have issues around identity theft. I know that Australia Post did this very well last year, and a number of organisations are implementing similar processes. And it's real, technology changes, data breach changes. It's important to be able to review the plan and review the plan annually. Anyway, we have received a significant number of questions today, and it's not going to be possible to answer them all. So what we're going to do is we're going to take the top 15 questions. We'll answer them in detail, and then we will email them out to all the participants over the next few days. So what I would like to say is thank you from the team, from Tim. Can't thank you enough for your time and effort. For Hayley for answering the dozens of questions that have come through on text. And we'll hope to see you at our next webinar. Thank you very much.